Next from Springfield, we head to a committee hearing on Governor Rauner's workers' compensation reform bill. This runs about 40 minutes.
We have before you two bills today, workers' comp and lawsuit reform. Both of them, as you know, are part of the governor's reform agenda. These are items that he has prioritized. They both are the result of bipartisan and bicameral discussions, and legislators have been working with the governor in order to try to find common ground. They do contain compromises and suggestions from the Democrats, and it is a sincere effort to try to move the ball forward and break the logjam that we seem to have in this building at this moment. Before I get to the specifics of the first bill that we want to talk about, I want to mention a little bit about the process. I certainly am well aware that we're late in the process and that we have a budget that we have yet to settle. But it is not too late, and all of us in this building know that where there's a will, there's a way, and we have been successful in passing other major pieces of legislation very late in the session. A couple of examples: Tier 2 pensions, and early voting, online registration, and of course budget bills, which often come very late. Furthermore, these initiatives are in fact directly related to the budget. They affect the economic climate of the state, which when it's healthy and it's growing, creates jobs and importantly creates revenue. We've seen what happens when we've tried the approach of just raising taxes to solve the problems. It simply doesn't work. Illinois has lost over 300,000 manufacturing jobs in the last 15 years, but it's lost other jobs as well, not just manufacturing, to our neighboring states. Work comp costs also importantly are directly related to the budget, and they have an immediate effect on the budget because governments, local as well as the state government, pay high work comp costs. Also, other entities that the state funds, such as human service agencies and healthcare providers, pay significant work comp costs, and that impacts our bottom line as well as theirs. We need reform to make Illinois competitive again, and while I acknowledge that some of these reforms may take a little longer to show that impact, we must begin the process of reform now. We must provide more jobs to Illinois families, which means fewer people on public assistance, and it means more resources for those who truly need the help. The longer we begin these reforms, the deeper the hole that the state finds itself into. We do need both a balanced budget and reforms, and this can be the beginning of that process. I'd like to ask Rich Goldberg, if he on behalf of the administration, if he has some open remarks on both bills, and then I'll get to the work comp.
Thank you, Leader. Thank you, Mr. Chairman, members of the committee. Rich Goldberg, Deputy Chief of Staff for Legislative Affairs for Governor Rauner. I'm pleased to be here today to testify in support of the governor's compromise reform proposals before you, specifically this morning on two important reforms to make Illinois more competitive so we grow our economy and create more jobs. I want to thank all members from the House and Senate, Democrats and Republicans, who participated in working group sessions for the last several weeks. These were productive working groups. Important questions were asked. Specific concerns were raised. Constructive criticism was offered. And we believe that the compromise legislation before you today addresses most, if not all, of the concerns raised during the course of the working group sessions. The bills before you are critical reforms we need to turn around Illinois, to grow our economy and make Illinois more competitive. These reforms are fundamentally linked to our budget. Taxpayers are fed up pouring more and more of their hard-earned money into a broken system. Passing fundamental structural reform to grow our economy will have a lasting impact on our state's future. I would note that while these key reforms are being considered today by the committee, there are two other pieces of the governor's turnaround agenda that have not been assigned to committee as of yet: a constitutional amendment to impose term limits on legislators and the executive, and a fair map constitutional amendment to end political gerrymandering. We would urge the Senate to bring these constitutional amendments to a vote as well. I want to thank Leader Radonio for her leadership on the turnaround agenda and for being here today to carry these important reforms. Aaron Winters, the Governor's Deputy Chief of Staff for Policy, Jennifer Hammer, the Governor's Senior Policy Advisor, has joined us this morning. They'll be on hand as well later on during Q&A to help with us and Leader Radonio in answering any technical questions of the bills before you. And with that, I'll turn it back over to Leader Radonio. Thank you.
Thank you. I'd like to start with the work comp bill, 994. This is an issue we're all familiar with. It's an important issue, and it's one that is frequently and frankly almost universally cited as a detriment to do business in Illinois. Work comp rates right now are the 7th highest in the nation, but that's actually progress. We've been here before. In 2011, we took up the issue when we were the 4th highest work comp rates in the nation. We were able to move the needle a little bit with the reforms that we passed at that time, but not enough. I refer back to the debate on the floor debate on that issue when Senator Lightford said, quote, "I think it's really important that we embrace our business climate and let them know that we too are on the side of on this side of the aisle are about business, because if there is no business, then our people aren't working." Let me repeat that. If there is no business, our people aren't working. In April 2012, after we passed our reforms, the Attorney General, Lisa Madigan, called upon the General Assembly to, quote, enact further reforms. She said, quote, "The current law and decisions interpreting the law make it extremely difficult for employers, including the state, to successfully defend these cases and limit costs. The reforms that the General Assembly passed last spring made important, necessary improvements to the law, but further changes are needed," end quote. Her report conceptually addressed each of the items that we will be discussing today. We need additional reforms in order to make us competitive. We don't have to be the cheapest rates in the country, but we do need to get to the middle of the pack. Illinois, as I mentioned earlier, has lost over 300,000 manufacturing jobs, and workers' comp has been a factor in that. We've lost other jobs as well, and I know Senator Conley will be talking specifically about a situation in his district, or I hope he does. Again, the point here is to become competitive and grow our economy and jobs. Further, as I mentioned earlier, work comp has a huge direct impact to local and state government, but also to healthcare and human service providers, which are paid by the state. So to the extent that we are able to reduce work comp costs, we help our bottom line and theirs. That budgetary nexus is important to note. Specifically, this bill does 7 things. It addresses causation, which we've talked about at length. It increases the causation threshold to 50%. This will require that the workplace be a major contributing factor to the injury, more than 50% responsible. It will require objective medical evidence of an injury. This is simply common sense. Employers should pay if the workplace is the major cause of the injury. If it's not, employers should access their health insurance or the civil court system. One of the suggestions that was added at the behest of Representative Bradley in his concerns about that causation language was that this bill would now allow an employee to recover for repetitive trauma costs by aggregating all repetitive trauma while employed in the same occupation or industry. The frequently used example is someone who has had multiple employers but has been, say, a jackhammer operator, so the workplace injury is actually cumulative. That would be still allowed. The employer would be liable for compensation is the most recent current, in that case, the employer that would be liable for the compensation is the most recent current or former employer, provided that employee has been with that firm for at least 3 months. Without this provision, there could be a denial of the remedy for cumulative and repetitive trauma. So we thank Representative Bradley for that addition. And secondly, there's a provision here regarding offset. So in determining the settlement for settlement for permanency paid to an employee who previously suffered an injury, the award for the prior injury will be deducted from any award for the subsequent injury to the same body part. Again, this is common sense. It was accepted practice. However, a contrary court decision in Will County overturned that common sense practice, and we now would like to return that and make it the law. Thirdly, the AMA guidelines. This will allow arbitrators to base disability on any single factor. It requires the commission to consider independent medical exams in addition to the treating medical records. Fourthly, the traveling employee. This codifies a recent Supreme Court decision on the definition of a traveling employee. It also requires that the travel, first of all, be reimbursed by the employer, and that part of the employee's job duties are a condition of the compensability under this act. I'm losing track of my numbers. I guess this is sixthly, the medical fee schedule reduction. This strategically reduces some medical payments by an additional 30%. It is not an across-the-board reduction. Medical payments will be reimbursed at 49% of the fee schedule amount. Current law reimburses at 70% of the fee schedule. It is worth noting that the Workers' Comp Commission can and has increased rates when the rates have actually resulted in access to care issues. So there is a remedy there. And finally, there are changes that were requested by the commission. It allows the chairman to assign and reassign arbitrators to hearing sites throughout the state. It removes the requirement that state constitutionals, boards, commission, agencies, higher ed institutions, and funds administered by the treasurer post bond in comp cases. So that is the essential nuts and bolts of the bill, and now I, with the assistance of the expert team, will be happy to try to answer any questions.
Well, what we'll do, Leader, is we're going to have the rest of the
panels.
proponents.
That's perfect. Okay, and then
before we do, next speaker.
Thank you.
Thank you.
Members of the committee, thank you for having me. My name is Brad Migdal. I'm a corporate site selector. My job is to advise companies on where the best place to locate for a business is. Part of the job is I aggregate data and I start to evaluate what is the most competitive cost for a particular company to locate. Workers' comp tends to be one of the issues that we look at because we're not looking at the average wage, we're looking at the total wage comparison. We're looking at how much it's actually going to cost to manufacture a product. When we talk about manufacturing companies and companies as a whole, margins are slimmer every single day as we're in a global economy. And being in Illinois, we're in a global state that's competing in a global economy. So for obviously reasons, the lowest cost on human capital is always a beneficial thought. So what I wanted to share with you today, just to try to give you an idea, is when you look at the MSA of the Chicagoland area, you don't just look at a one-state economy, you look at an interstate economy. You're looking at Indiana, Illinois, Wisconsin, but those aren't the only two states that border the state. We're also looking at Missouri, we're looking at Iowa, we're looking at Kentucky to the south. So we're competing on a day-to-day basis here in Illinois to provide the lowest cost for a corporation to do business. So one of the items that I just wanted to talk to you is I'm assuming everybody in this committee has had a Jolly Rancher. So think about making a Jolly Rancher. Jolly Ranchers, if you go to a gas station, probably cost about 10 cents. So you gotta hope that the company that makes a Jolly Rancher probably is gonna pay about 8 cents for each Jolly Rancher. So if you're a candy manufacturer on Illinois Workman's Comp Code 2041, you're paying $5.63 per 100 in Wisconsin versus $10.47 for Illinois. That basically equates to $1.58 more an hour, $1.58 extra per an hour on the base wage in Illinois versus 84 cents in Wisconsin. So when you're looking at an employee that's making $15 an hour, you're talking that the loaded wage, including workers' comp, is $16.58 an hour versus $15.84 an hour for Wisconsin. When a client of mine is looking to make a 10-year decision and looking to make a decision in a state, that's what they're looking at. They're looking at a cost that is so much different. It's 2 times as much being in Illinois. So all I'm saying is that I look at data and aggregate data on a day-to-day basis, and as long as costs are higher, Illinois is just going to get cut from being on the short list for companies coming to Illinois.
Thank you so much for your testimony, gentlemen. Mr. Bays.
Mr. Chairman, thank you. It's a pleasure to once again be here. I was thinking this morning that most likely in my career, I've sat in this spot talking about this issue more than a dozen times. So we, in this General Assembly, have taken up this particular issue. The call for workers' compensation reform is not new. In 1975, the General Assembly turned the system really upside down, created a disincentive to really disinvest in Illinois. Since that time, on 5 or 6 occasions, the General Assembly has tinkered with this system. But the reality is that workers' compensation remains an anvil around the neck of Illinois and economic development and increasing jobs. And it is something that needs to be addressed and needs to be addressed quickly. It's not to say that the work that has been done in the past has not been successful in some areas. In 2011, Illinois ranked near in 2004, Illinois ranked near the middle of the pack, 23rd, in costs against our neighbors around the country. Following a 7.5% benefit increase in 2005, the cost of workers' compensation in Illinois skyrocketed, and we became the 3rd highest in the nation. In 2011, Speaker Madigan, President Cullerton, Leader Radonio, and you, Senator Raoul, and others on this committee came together around some reforms. Those reforms made some positive effort, so it shows that it can be done. I won't go through those reforms today. They have been talked about, but it is, I think, instructive that if both sides of the aisle and both sides of the chambers and the governor who has pushed this issue to the top of the list can work together, we can see improvements made. I don't really think that we want to become Indiana. A lot of people have talked about that in the various past few weeks and use it as an example. There is no doubt it is a very competitive disadvantage, and you heard from the steel fabricating company. I hear this message all the time of how much cheaper it would be for my company to operate if I moved just across the line. But as I said in my testimony in the House of Representatives about this issue, it's still Indiana, for Pete's sakes. We don't want to become that. We want to become competitive. We want to be in the middle of the pack. We want to make sure that injured workers are taken care of, but this is a system that is about money. It's a $3 billion system that operates each year with payments to medical providers and payments to injured workers for their loss. And the statistics that you can put and look at, bipartisan organizations that look at these factors can show you exactly what the difference is. For example, the ProPublica study that is often cited by some of our friends on the labor side of this issue talks about how much are you worth in a presentation that they put forth. And they compare various states for the loss of an arm as an example. In Illinois, the loss of an arm is worth $439,858. You hate to say it in those terms, but that is indeed what is it about. In Ohio, the same loss of your arm would be $193,950. And in Alabama, it would be $48,840. The national average, $169,878. You can go on with various body parts and talking about that, and you can go into examples of how much higher the medical fees are in this state in compared to other states. That's what you have to deal with, ladies and gentlemen. It's not easy, but that's the essence of workers' compensation. I applaud the governor. I applaud all of you in the past for your efforts to bring this issue to the fore. But as you've heard today, the hemorrhaging of jobs, 300,000 manufacturing jobs since the turn of this century alone, ought to give this General Assembly pause and think about what we can do in a balanced approach to solve this problem. Thank you, Mr. Chairman.
Thank you. And thank you in particular for making the point that we don't want to be Indiana, which I think is a very critical point in this discussion.
Good morning, Mr. Chairman, members of the committee. I'm Michael Kerrigan. I'm the president of the Illinois AFL-CIO. Has been said many times, in 2011, injured workers gave up significant benefits in exchange for the promise that premiums paid by Illinois employers would significantly drop. Unfortunately, that has not been the case. Worker compensation is not the problem. It's part of the solution. It is the solution. It provides that ability for injured and disabled workers will not fall through the cracks. It is a valuable economic tool keeping people above the water in very difficult times for themselves and their families. The injured workers of this state should not be in the middle of this trickle-down economic theory of the governor, nor should they make concessions yet again when the answer clearly lies with insurance regulation. The governor should look at the profiteers of the system for reform, the insurance companies. He should not attempt to emulate the worst of the states in a race to the bottom in protecting our sick and injured workforce. Mr. Chairman, if it's acceptable, I'd now ask Mark Poulos, the Executive Director of the Indiana, Illinois, Iowa Foundation for Fair Contracting, to make comments.
Thanks, Michael. Mr. Chairman, members of the committee, Mark Poulos, Triple IFFC. We're the labor management group of the operating engineers, Local 150 out of Chicago. I just want to talk really on one point of the current reform package that's being proposed, and that really goes to cost shifting. I mean, that's essentially what we're talking about here, right? We're talking about taking a segment of the population and removing them, right, from a system that they currently are covered under, but moving them to something else. So for the union employers and the union members out there, what it means is moving them from a contained workers' compensation system and simply moving them over to the group health insurance system. Currently, for operating engineers, Local 150 employers, it costs $17.55 for every hour an employee works for the group health insurance system. So if you take the per $100 of payroll, it equates to about $35 for every $100 of payroll for the group health insurance side. What you're talking about is moving, cost shifting from a current contained system onto an already strained system, that being the group health insurance system. It also means that talking about this outside of the union context is you're moving somebody from a system into their normal group health insurance system for a non-union sector for a population that, at least for Generation X members, almost less than 50% of them are covered under a long-term or short-term disability policy. So what happens to those individuals? They may get their hospital costs covered, but they have no STD and no LTD for any other kind of coverage that they need. What it's going to do is drive in negotiations with union contractors, if this in fact were to pass, the causation standard and the traveling employees, would be that there would then be negotiated long-term disability and short-term disability policy coverage in collective bargaining agreements. Because the reality of it is at least for union members, it's cradle to grave. So we take care of the members from cradle to grave outside of workers' compensation. That is the one area where we do not handle anything for those members. But if we're gonna move a segment of those people off of this contained system into the group health insurance system, those costs are going to rise. So at the end of the day, being more competitive, and I'll close with the kind of some stats on Indiana, because I'm glad Mr. Bays brought this up, right? Outcomes matter, right? And outcomes in Illinois for employees, it's been good. It's good for workers. So when you're looking at this, and I think it was Senator Harmon that was talking about this, you know, we have to look at this at a much more global perspective, right? We can't just look at how do I contain that cost today. We got to look at how do I contain the cost long term, and how do I take care of the employee at the same time. So here are the stats on Indiana versus Illinois, because everybody seems or a large segment of folks like to compare us to the state of Indiana. In Indiana, who just, by the way, repealed prevailing wage, so wages are also going to continue to go down in that state. They're in the lowest 20th percentile of prosperous states in the entire United States. They rank 6th in income inequality, 36th in per capita income in private sector jobs. In Illinois, we rank 17th in personal income, 7th by average weekly wage, and 15th in income inequality, even though we have a massive financial sector with big banks and the Board of Trade, right? We do much better in the state of Illinois for employees. We do not want to be like the state of Indiana. So if we're going to compare who we want to be like, we should compare it to states that actually take care of their employees. Thank you.
Mr. Manchetti.
Good morning, Mr. Chairman, members of the committee. My name is Dave Manchetti. I'm a workers' compensation lawyer, and my firm has been technical advisors to the state AFL-CIO on workers' compensation issues for many years now. I'm going to abandon my written comments for the sake of time, and I'm just going to try and hit a few highlights from them. You've already heard that when you define issues like major contributing cause arising out of and in the course of repetitive trauma, traveling employees. When you define those terms, what you're actually doing is restricting or eliminating compensation for classes of individuals who fall under those definitions. The problem with eliminating coverage under workers' compensation for those types of individuals is that you're doing the cost shifting that Mr. Poulos has already talked about. You're cost shifting things like medical costs and lost wages onto other systems, sometimes public systems like Medicare or Medicaid. So when you eliminate compensation for injured workers, those costs go somewhere, and sometimes they go to public programs. The other thing that you do when you eliminate coverage for injured workers, and this has already been mentioned, is you may be creating civil liability for employers under certain circumstances. Certainly states like Missouri, who have adopted a heightened causation standard, have experienced this problem about, when you cut out individuals from coverage under the workers' compensation law, what you're actually doing is creating civil liability on the back end. And as already been mentioned, I'm not sure that there are any employers in the state of Illinois who think it's a good idea to be creating civil liability for workplace injuries where you have unlimited verdicts like Senator Harmon has already talked about. And the problem is, of course, is that we have a constitutional provision in Illinois that says that and it's not a problem, it's a good thing, of course, but the issue is we have a constitutional provision in Illinois that says that when there's an injury or a wrong, there has to be a remedy for that. And that's what creates the civil liability when you eliminate individuals from the workers' compensation provision. Of course, things like major contributing cause fall on the most vulnerable types of individuals more heavily. Older workers, workers who have worked in heavy occupations for all their lives, are those types of workers that are more likely to have pre-existing conditions that would be excluded from coverage if you adopted something like major contributing cause. So as somebody has already mentioned, there may be an unintended or perhaps intended consequence of eliminating individuals from coverage under the Workers' Compensation Act, which is this idea of creating civil liability on the back end. I had a lot to say about some of the other provisions in the bill, but I'll skip those, and I'll just get to two of them very quickly.
Very quickly, please.
I'm sorry, Senator. The 30% reduction in the medical fee schedule, as many of you know, there was already a 30% reduction in the medical fee schedule in 2011, and certainly that created some limitation of access to high-quality medical care. In fact, a large rehabilitation hospital in Chicago had to apply for an exemption to be exempted from that 30% cut. An additional 30% cut will undoubtedly limit access to high-quality medical care. You're going to hear from some other experts about that. The AMA guides have already been mentioned. The book itself says that it should not be used as the only factor in determining disability. Senator Raoul cited right to the page of the book, page 5 of the book, which requires the consideration of subjective factors like pain, how age affects a person's ability to recuperate. We've talked a lot about what is in this proposal. Let's please just allow me another minute to talk about what is not in this proposal.
45 seconds.
Okay, thank you, Senator, because I'm going to talk really fast, because that's almost as important. There's no requirement that the National Council on Compensation Insurance calculate a rate reduction as a result of the proposals here, which was done in 2011. And by the way, that rate reduction that was calculated by NCCI for the 2011 amendments was a 20% rate reduction since 2011, 20% rate reduction. So the gentleman from the steel fabricating plant who indicated that his premium actually went up 20%, please keep in mind that that's during a period of time when NCCI was actually recommending a 20% rate reduction. That's a 40% swing as far as I can do the math. And that brings up another missing component of this bill, which is there is no proposal in this bill for insurance premium reform or rate regulation whatsoever. And premiums are really important to most of the employers in the state of Illinois. As you've already heard, 99% of the employers in the state of Illinois have only one workers' compensation cost, and that's their insurance premium. 85% of the employees in the state of Illinois are covered by workers' compensation insurance, and 75% of the benefits are paid by workers' compensation insurance. So premium reduction is really important. Lastly, there's absolutely no emphasis in this proposal on what's really important: prevention and safety. Prevention and safety are what really reduce workers' compensation costs, and there's nothing in this bill about that.
Thank you, Senator Rowell, members of the committee. My name is Kim Janis. I'm here testifying on behalf of the member physicians of the Illinois State Medical Society. I, too, am going to abandon my written remarks and get straight to the point on a couple of things that were talked about today. The Rauner turnaround agenda, unfortunately, does not have footnotes and has made specific claims about specific medical procedures and their costs on the medical fee schedule. What I want to point out to you today is right now I could build a hypothetical patient who has major comorbidities like diabetes or obesity, place them in the region having the highest medical fees, and also add several complications. My point being that this is the price paid on the medical fee schedule, which doesn't necessarily reflect the cost drivers in workers' compensation. So what I would instead ask you to look at is data from WCRI, which examines the cost per medical claim. So again, we're not looking at individual reimbursements. We're looking at the total cost per claim. What that is made up of is the prices paid for the service multiplied by utilization. Just a fancy word for how often things are performed. And what WCRI reports is that these prices per claim in Illinois are falling. In fact, they've fallen 12% since the implementation of the 30% fee schedule reduction in 2011, and they've fallen farther and more quickly than all the other states in the 16-state study where WCRI has examined. This decrease in the medical price per claim has also accompanied a decrease of utilization, 3% by non-hospital and hospital inpatient providers. What I forgot to mention at the beginning is we're opposed to these reductions set forth in Senate Bill 994. What I'm also going to talk about is a few specifics about the way this bill is drafted. We believe that as drafted, this bill contains a 51% reduction to the medical fee schedule. I don't mean to bother you with the math problem, but if you look at the exact language of the bill, which is pretty much copied from what this august body passed in 2011, it states that the medical prices paid on the fee schedule shall be 49% of those prices as they are listed now. Now, those prices have already been reduced 30%. They've also been altered because the GeoZips, which previously made up the fee schedule, have also been reorganized into 4 non-hospital and 14 non-hospital regions. In addition, a CPI adjustment has occurred every year. So what I'm saying now is the plain language of the statute implements a 51% cut. Now, there's been talk that this cut is targeted to certain fee schedules. Again, we have a problem with this language as well because it appears to be an unconstitutional delegation of a legislative authority. If you look at the exact language of the bill, because I know everyone has it right in front of them, but on page 73, there's a reference to sections 1, 2, 6, 7, and 8 of the fee schedule. Providers, along, I'm sure, with your legislative staff, struggled to find what these sections were, as they're not in the Workers' Compensation Act. Where we did find them is in a document called the Instructions and Guidelines, which is a guidance document developed by the Commission to assist providers and coders on how to implement the fee schedule. It's not a law and it's not a rule. I know that the case law involving the constitutional delegation of a legislative authority does provide for some instances where that is allowed, but what is clear is that when there's no restriction on how to make this document whatsoever, it's a legislative authority that's basically put in a document that's updated by the Commission and published on their website. I know Mr. Wilhelmi is going to talk more about some of the access to care issues that have been faced by medical providers and hospitals in this state since a 30% reduction, and also talk about some of the specific duties and responsibilities of physicians that are unique to the workers' compensation patients. Now, these are things that a regular group health or a Medicare patient is not required. Things like following up with nurse case managers, things like utilization review, actually contacting a doctor in another state as they debate as whether the treatment is authorized. Thank you very much for your time, and I'm happy to answer any of your questions.
I appreciate you addressing the details of the bill. Senator Wilhelm.
Thank you, Mr. Chairman and members of the committee, Leader Radonio and representatives from Governor Rauner's office. It's good to be here this morning with you to discuss this important issue, Mr. Chairman, and I know we've had many discussions about workers' compensation over the years and really appreciate the seriousness and the deliberation that's being given to this very important issue. And I know as you debate this issue, you recognize, every one of you I know recognizes the important role and really mission that Illinois' hospitals have and feel strongly about in communities across the state of Illinois to provide the very best quality health care to every person in this state. And really to ensure access to quality care for injured workers, really to entire communities. IHA and the hospital community strongly opposes an additional cut to the medical fee schedule after the 30% cut that was implemented just 4 years ago. It does seem like just 4 years has gone by fast, but when you think about it, when we looked at the 2011 reform package, a 30% reduction was considered significant by you, many of you who voted for it, by the provider community, and here we are again talking about taking yet another cut to the medical fee schedule just 4 years later. And as you know, when these cuts take place, hospitals are businesses and they have decisions to make. They have decisions to make on what array of services to provide in their community. And so when these cuts are made, or if this cut was to be imposed, we feel strongly that physicians and hospitals would really have to think very seriously about whether to continue providing health care services to injured workers in their communities. And so, of course, when services are eliminated, they're not just eliminated for one payer type, right? When a service is eliminated, it's eliminated for everyone in the community. And so we have great concerns that at the end of the day, if another cut to the medical fee schedule was imposed in 2015 after the 30% cut of 2011, there would be serious challenges and issues with access to quality health care for injured workers and potentially for everyone in the community. We also know that you look at everything in context, that the workers' compensation fee cut is not in isolation. It's not in a vacuum. That discussion is in the context of other pressures that your hospitals are facing throughout the state of Illinois. We know that over the past 4 years, Illinois hospitals have sustained $1 billion in cuts under the Medicaid program over the last 4 years. Under Medicare, Mr. Chairman, about $2 billion in cuts over the past 5 years. And over a 15-year period starting in 2010, Illinois hospitals will suffer about $17 billion in reductions under Medicare alone. And of course, there are pressures under the commercial payers. And the movement towards transformation we are committed to make sure that we get the very best quality health care provided to everyone in our communities across the state, that we improve outcomes, and that we lower costs. But there's no question that when these cuts take place, there is real implication. Right now, 40% of Illinois hospitals are operating in the red. And that's because of those pressures, the workers' compensation cuts, the other cuts I've mentioned. So when we move down this path, we think it's very important to keep it in context with the other challenges that Illinois hospitals are faced with in this state. And so in closing, very briefly, we feel, number one, that access to quality health care for injured workers and potentially for everyone in communities will suffer if another medical fee schedule cut is imposed. Number two, that we feel very strongly that providers need to be at the table when these discussions are taking place and when these decisions are being made. Please hear from the provider community, including hospitals and physicians, as these decisions are made. And finally, we know that you appreciate the mission of hospitals to provide the very best quality health care to the constituents in your districts. We are committed to that mission. We want to continue in that mission, and these cuts will make it very challenging to do so. So thank you, Mr. Chairman and members of the committee.